The gold that is in here that was revealed by having pierced the attorney-client privilege relates to the obstruction charges, rather than what I'll call the substantive charges, the 31 counts of retaining classified and national defense information. At the time that the application was made, there clearly was sufficient evidence to satisfy the then Chief Judge, Beryl Howell, because they knew that there'd been a certification saying that everything had been turned over, that a thorough search had been done, and then they knew that wasn't true because they had done a search and there was much more stuff. And as we knew from reporting, there was some indication that they had been talking to people at Mar-a-Lago and had a sense that this was intentional, that boxes were moving, that there was a reason to think that when they filed that certification, it was not true. What the government probably didn't know was, are the lawyers in on it? Were the lawyers duped? Who gave the instructions? That's those kinds of details. And the basic rule is, you know what, attorney-client privilege is sacrosanct until and unless you as the client are trying to solicit a crime that your lawyer is participating in. So that is not something that is privileged. And you obviously need to go to a judge, and the judge has to agree that you've established that. And Beryl Howell found that it was. And then this was a gold mine, because essentially you have Mr. Corcoran relaying chapter and verse how he was duped. Not only how he was duped, but basically the former president, according to him, and as recounted in these charges, solicited him to go along with the crime of not turning things over. And there's just a list of all the things. I mean, the two sort of most sensational paragraphs are paragraphs 54 and 55. You can see we're all in the weeds now. And in paragraph 54, basically the former president is saying, why don't we just say we've turned everything over? Or why don't we...
Which is a crime.
A total crime, because he knew that hadn't been true.
Why don't we commit the crime this way?
Of lying to the Justice Department. Or why don't we just make them disappear? And he goes further.
Why don't we commit the crime this way? He gives us various options for how to commit the crime.
And the third one, which is my favorite, is why don't you do it for me so I don't get in trouble? And then he says that's what Hillary Clinton's lawyer did. I mean, there's no proof of that, but he basically is said to have repeated that during the day. Here's a third way to commit the crime. And Mr. Corcoran, to his credit, is like, no, I am going to do a search. And the reason for the moving of the boxes, according to this indictment, is because Mr. Corcoran is saying, no, I'm not losing my bar ticket and committing a crime. So I'm going to do a search, which is required by this subpoena for these documents. And so that led to Donald Trump going, OK, you're going to do a search? Give me a moment. And what's outlined here is he said, where are you going to search? You're going to search the storage room? Great. I'm just going to take everything out without telling you. Now go in and look at the storage room.
Yeah. Neil Katyal, so Evan Corcoran's behavior is, I think, fascinating here, because somewhere there's a line. There's a line, and he's trying to make sure that his foot does not go over that line. He can't get his foot on the chalk, or he has committed a crime here. And so there's a reading of this in which you can say he stayed right inside the line, even while the client's in the room with him asking him to commit crimes. He stays right inside the line because he doesn't commit those crimes. But with a client who has asked him to commit crimes, which he has not committed, he then, on behalf of that client, gives to the FBI and the Justice Department a document written by Evan Corcoran that says, we're giving you everything that we have here. He will maintain that that was the representation that he got from Donald Trump, that this is everything. But he already knows Donald Trump is highly criminally minded, so criminally minded, he's trying to get Evan Corcoran into committing a crime with him. And so this is what I'm trying to find here is, when Evan Corcoran hands over that document that he wrote word for word, telling the FBI, you're getting everything, and he knows he's doing it on the basis of information that includes someone who he has seen attempt to commit crimes right in front of him. Isn't Evan Corcoran getting really, really close to an active, knowing misrepresentation in that document?
Possibly, Lawrence, but this case is United States versus Donald J. Trump. It's not United States versus Evan Corcoran. And I think the focus has to be on Donald Trump's wrongdoing, not on the others. And that's so for any host of reasons, but I think the most obvious of which is Evan Corcoran might have said when Trump tried to get him to do all that stuff, which is detailed in paragraph 54 of the indictment, Corcoran might have thought to himself, well, none of this stuff was actually classified in the end because Trump is telling me it's declassified. And maybe Corcoran hadn't, maybe never didn't have experience with national security information, didn't know just how bananas such a defense would be. And so he could have acted in good faith. It's possible. I think Andrew makes the, very important point that regardless of Corcoran's good faith at that point, what ultimately was litigated and brought to this very respected judge in Washington, D.C., Beryl Howell, and then ultimately to our nation's second highest court, the United States Court of Appeals for the District of Columbia Circuit, is should attorney-client privilege and these Corcoran notes be given over to the prosecutors? And they took the radical step, really unique, of saying this is so serious, this crime, and Trump was using his attorney to try and commit it. So they, basically pierced attorney-client privilege. That, to me, Lawrence, says all you need to know about this case, that you have our nation's second highest court saying this isn't some political investigation or something like that. This is such a serious matter, and Trump's actions were so lawless that we had to pierce attorney-client privilege, kind of the most sacred privilege in Anglo-American law going back, centuries upon centuries. And that, to me, is why, I listened to Jack Smith's press conference today, and the most important words he said were, to all Americans, read the indictment. You and I heard lots of nonsense from the Republican Party about what that indictment was last night. No one read it. But now we all can read it. And this is not the kind of bare bones indictment prosecutors typically file. This level of indictment about the alleged crimes is extensive. It's kind of a hippopotamus. It's a speaking indictment for this prosecution. And it speaks loudly and clearly, Lawrence. It says that they have damning evidence against Donald Trump, and a lot of it, and the most notable part, is that it comes from Donald Trump's own words. It's damaging statement after damaging statement from Donald Trump himself. And in many ways, it's Trump's big mouth that did him ultimately in. And